Hello everyone. I just wanted to check first whether everyone can see and hear me. Please write in the chat if you have an opportunity to do so. By the way, if you have any technical questions, please also write your questions in the chat and our IT people will solve the problems. So we can start from the beginning, and the other people will join us later when they have time. So today we're gonna speak about software protection in Russia, especially from the angle that the Russian Civil Code has undergone certain changes and amendments, and they came into force. The first package came into force in October 1st. And recently, the second package came into force on January 1st, so quite recently. And a lot of these changes were made in connection with copyrights and certainly software products. That's why it is very important to know for the IT people, for the lawyers that protect their IT within the company, what are the changes about, and basically what is the law about, because the changes always happen to the law, and first we need to concentrate, of course, on the basics of the law. So today we're going to speak about almost the strategies and the action plan for the development of figures and the money. Then we're going to speak about the computer programs and databases, because these are the basics of the software, and that is why the business apply them. Also, we're going to concentrate on the issues in relation to software ownership and software licensing. And in the end, we're going to talk about the software protection and how we can enforce software rights. On this slide, you can see that there are quite a few of laws and regulations that protect software and information in the software and content in the databases. So the principal law is the Russian Civil Code, and especially Part 4, which regulates copyrights and related rights, and therefore protects software rights and database rights. In case databases, and it is very often, contain certain personal data, then the law on personal data will apply, and the law, the so-called IT law on information and data protection, will be also applied. There are a few of enforcement codes that will apply depending on the liability that you want to lie on the infringer. That's why I mentioned criminal code and code on administrative offenses here, depending on the prosecution and liability of the infringer. In 2013, the Russian government published the strategies and the action plan for the development of IT sphere. These documents are mentioned on this slide. You can see that this is the so-called Russian IT industry development strategy and action plan for the development of IT industry. And the years are also mentioned. So you see that until 2025, we have the perspective for the development of this sphere, because software products and are very much related to IT. So among the most popular strategies are the training and professional development of IT people, the improvement of institutional conditions, the IT infrastructure, and other basics which can be which can be seen in these documents. If someone from you wants to see these documents, you can send us the email and we will send it to you along with the English translation if you need them. This is just a comparison slide showing that we are not far from Europe, and in certain cases we are at the top of the list, especially in hardware industry. You can see that we are crossing the Europe, and we are almost catching up in terms of IT services and software. Basically, our scientists and IT people are very knowledgeable, and they have a nice software background, and that's why the IT business in Russia has always been popular and also popular nowadays. So this slide shows that we are very close to Europe, and we can also produce good products. Speaking about the companies that are very famous in Russia and very famous especially in the IT area are the Kaspersky lab, which is the company that named 54 at the top list of software companies all around the world. So it's directly in the middle nowadays. I can also cite the so it's the sales result of this company, and the turnover is $750 million. So it's quite a big company. They also, one of the famous is the Iota company, and it's famous for its unique double screen smartphone, which this company has created recently, and they always apply many software products, whether they develop themselves or whether they license them, whether they acquire licenses. So this company is very developing in the software area. Also, the company called the Russian vendor called Parallels. It was also included in the top 50 leading suppliers of cloud virtualization, and according to the American CRN magazine. So it is one of the most successful suppliers of virtualization solutions. And others working in the internet sphere, such as Mail.ru and vKontakte and other companies. So they also provide IT services. Foreign companies, of course, are at the top of the list. You can see that all famous American companies, Google, Microsoft, Intel, IBM, they work in Russia, and all of them have Russian R&D centers, and of course they supply and license their software products very actively. This is basically the structure of the Russian IT market. You can see that software products is number 2 on the list, and we provide not only, of course, software products as such, but we also do mobile phones. Iota is an example. We also do telecommunication and network equipment. Produce and very famous companies, Russian companies in telecom sphere is Beeline and MTS, but this is the topic of another presentation. Also, we produce personal computers and provide IT services even in clouds. So we will talk about clouds a little bit later. This is just a diagram showing that software products which we produce are very much exported outside of Russia, and you can see that every year this goes higher and higher, meaning that the software export volume is growing, and of course we're never going to stop because this is one of the key economic areas in Russia. So let's move to law and talk about computer programs and databases which may form the software products when people do business with them. First of all, please see the principal characteristics of these rights. So these are basically the intellectual property objects that are applied in the IT area, in technology and telecoms area. They are very much complementary, meaning that they cooperate with each other. For instance, there might be a computer program in which the database is implemented, and this database cannot work without the software. So this is obvious. In other words, the database is not just the papers; it's the database content, which one can see when they open the software. Everyone must remember that IP products are always creative and original products. That's why computer programs and databases are not the exception. They must be created as a result of creative input, not just organizational or material input, but creative, made with the hands of the author, and then they will be protected. And these objects can have different forms of IP protection depending on the nature of the object, and enforced in different ways, meaning that different liability can apply according to the law. This slide shows how different forms of IP can apply to computer programs and databases. Basically, copyright will cover both the computer programs and databases. Computer programs will be regarded as literary works, while databases will be regarded as compilations, meaning that the selection, systematization, and arrangement of data content will be protected, not the data content itself. Comparing to the so-called related right, which will protect the database content from unauthorized extraction and use. So basically, copyright will protect the creative input of the author in terms of the selection of the content for the database, while the database maker, usually the company, will have the exclusive right for the database content, not the principles of selection. And there is also a very important patent right, which nowadays applies very rarely to computer programs and, of course, to databases. Databases can never be patented. However, computer programs may sometimes be patented, or some parts of the same may be patented. There are cases in Russia when algorithms associated with the computer implemented inventions or with the machines allowing to manage the software have been patented, and there are cases when the interfaces of mobile applications, original interfaces, have been patented as industrial design. Probably many of you know that designs are protected as via operation of patent law in Russia, and that's why I mean here that computer programs, their interfaces may be patented. However, my presentation today will be more concerned about copyright and related rights, and I will not talk about patent right in relation to computer programs here. Of course, if you have any questions or want to talk about the patentability of your software product, then you can always write an email and we will respond. Basically, what is a computer program? Computer program is a set of data or information and certain commands that are intended for functioning of computers and computer equipment for the purposes of achieving certain result. This result may be different depending on the area of the business, depending on the circumstances. And of course, depending on the task, for instance, of the employee, the IT guy who is in charge of creating a software program. So these will be the key elements that that the computer program will cover, and for which IP protection will be granted. First of all, it will be the source code and object code. The source code is the principal, I would say, document from which every computer program starts operating. So it starts with the source code, and then when it transforms or converts into the object code, then we will see the so-called audio visual depictions as they are made on our computer. So all of these elements, as listed here, will be protected by copyright, and hence will obtain IP protection. Speaking about updates, we need to mention the licensing, and that's why I need to say that we'll talk about this later, because this may be an issue in contracts, whether via licensing, the licensor, the owner, when licensing its computer program, automatically grants the license for the update. So this may not be a case in many situations. This is the slide showing the examples of computer programs. You can see that everything can be computerized and turned into software. This may be an operating systems which every one of us is using in our day-to-day life. Also, web browsers, drivers, very popular nowadays, especially for Androids and OS systems, are mobile applications. We usually install them to achieve that certain result. When I was talking about the definition, remember, I was talking about the result. So in order to do something, I don't know, to play a video game, to translate a word, everyone has to download a mobile application. So all of this will be regarded as computer inventions, and of course, computer programs, and of course this list is not exhaustive. These are examples of operating systems that already work in Russia, and the companies that produce them probably already known to you. So everyone may use the Android and Mac OS, and Symbian is very popular. Nokia, I know that Nokia was working with Symbian before the dissolution, so many of them are very famous. Commonly used database management systems, also very, I would say, popular software, and all of this is used in our day-to-day life. Again, returning to the law, computer programs, the IP right will will produce two different rights, whether having economic or non-economic effect. The moral rights and the exclusive rights. The moral rights, they cannot be transferred. They don't have any economic effect. They protect the author. That's why the author will have the right of attribution, the right of integrity, and the right of publication of their computer program. So, right of integrity, meaning that they cannot, the company cannot somehow intervene into software without his consent, and affecting the author's personality. The exclusive rights, they provide a bundle of economic rights, which may be licensed and transferred, of course, and in most situations they will be owned by the company or by the employer. We will talk about the ownership a bit later. So first of all, it's the right of reproduction, meaning that the computer program may be downloaded into the computer, and or may be produced by another company under license. So this is the principal right. Then the rights holder will have the right of distribution for the purposes of assignment, the right of rental if the object, if the software, if the computer program is the main object, and other rights in which right of modification is very important. Right of modification can include translation of a computer program into another language, and will never cover the right of adaptation, because the right of adaptation, meaning the right of changes, entering changes, is stays with the authorized legitimate user all the time. So not every computer program may be downloaded, and that's why the user or the owner will need some adaptation time, or will need to enter certain amendments that will be automatically granted by the law. And of course, the right of making a computer program public, meaning that you can use your computer program, for instance, as a video game online, so everyone can play it. These are especially the legitimate rights of owners and users, which are also granted by the Russian law, especially the Russian Civil Code. When you obtain the copy of the computer program, or when you obtain a license, unless the owner, unless there is an agreement to the contrary with the owner, the user can have the right to right of the so-called adaptation, as I mentioned it before. In other words, he can or she can enter necessary changes for the purposes of functioning of the computer program. Then the user can also have the right to correct errors and bugs, I don't know, malfunctions that the software may have, unless there, of course, there is an agreement to the contrary with the owner, because sometimes the owner would do it themselves. The archive copy is always sometimes an issue, it's especially in the licensing area, because the law says that when the legitimate use has been terminated, the archive copy must be destroyed. So this must be emphasized in every contract, in every license contract, so that the user will understand that this will not be legitimate, and maybe certain penalties need to be attended. Other rights, such as right of the compilation, when for the purposes of connection with other programs, the software has to be decompiled. In other words, the object code will be converted into the source code, and this is basically also the right of the user. Speaking about the database is a set of independent materials that are objectively formed, and they are systematized so that the user can find and process this information using the computer, and of course using the software. There are different examples of databases. So this is just a list. Well, in the IT area, I can name that the websites are very important on databases, and many of them are databases basically, because they consist of certain materials that are systematized in the form of the database, and that's why when we are about to create or sell our website, we need to remember about the database right which we own or which we license, in order to understand our rights. The databases may be creative and non-creative, and this is the big difference with the computer program, because computer programs are always creative, meaning that they are original, and the IT people always have a creative input. But databases, they can be creative and non-creative, meaning that there is no principles of arrangement, and the owner, the maker of database, has just provided the substantial organizational or investment input. So in this case, the database will be protected by related rights. On this slide, you can see the differences between creative and non-creative databases. So the principal difference is that the database content will be protected by non-creative databases, in the non-creative databases, and the creative database will protect the manner of expression of the principles of selection and arrangement of materials or content that is provided in the database. What about the thresholds for copyright protection? So this is the principle of Berne Convention that says that all international rights and the rights of international citizens will be automatically protected in Russia. The Russian Civil Code fixes the same principle. That's why the copyright, if someone has created a database outside of Russia, and provided this is there is a treaty between this country where this database was created, the database of this owner will be protected in Russia. In case again it is creative. For the non-creative databases, this principle will apply because they will be protected by the so-called database maker right. Database maker must, so in other words, there must be a reciprocity principle. In other words, if the Russian citizens, if the Russian citizen want to protect his database in outside Russia in another jurisdiction, the same rights will be granted by the other jurisdiction. So this is the principle of reciprocity that must be complied. In this case, the database maker right will be recognized. So what are the principal differences between the creative databases protected by copyright and non-creative databases protected by related rights? First of all, the input. Again, for the non-creative databases, there has to be a considerable financial, material, organizational, or other investment of the person. The law doesn't provide any criteria what is considerable and what is considerable investment or input. The law only says that 10,000 independent elements will be a presumption for the creation of right to a non-creative database. So in case there are 10,000 independent elements and they create the content of the database, then the database may obtain the related right protection. Again, the term of protection may be different. For the database that is non-creative, it will be 15 years, and will be this term will be extended every time the database is updated by the owner, and that's why it's very important to know if you obtain the license for the use of the database, when and how and if the owner is updating its software. Because if the owner doesn't update the database, then the database protection will expire and the license will automatically expire. So the contract for the database license contract should contain a provision that licensor, every time it updates the database, will, within the term of the contract, provide certain documents so that the licensee knows that he is acting in good faith and legitimately. Speaking about rights, the non-creative database will not have any moral rights because this is not a creative database, and therefore there is no author. Only the person, whether physical or legal person, that has created, organized everything for the creation of the database. So that's why there will be only the exclusive right, and other rights such as the right of indication of its name on the corpus of the database or its packaging. And I mentioned difference here, but I need to mention that the registration is available nowadays for copyrighted databases, as well as the databases protected via related right. Before October the 1st, we didn't have such rule, and it was a big question whether the non-creative database could be registered. If there were many talks by practitioners, and they were thinking that only creative database could be registered in ROS patent. By the way, this is just the beginning of the registration talks. These are the basic exclusive rights of the database maker that he will have in the non-creative database. So basically, it's the right of extraction of certain content and its further use For example, there has been a recent court case which hasn't been finally resolved. However, the Russian IP court said that the content which is contained in the social network group, everyone is using Facebook, everyone is I don't know, some of us using CONTRACTUAL or other famous social media, and this content that the group has, for instance, text, photos, some graphics, etc. This content may be protected as non-creative database, and that's why the person who created this group, who organized the systematization of this content, will be the database maker. The Russian court has ruled in favor of the company who sued the other company because the employee, he left the company and started the same. He extracted the database materials and started further use of the same in the new company. And this is a very interesting case, of course. If any of you wants to know the details of the same, we can have a small chat afterwards. So let's speak about the development and ownership, because this is very important. Many of you know that software and database, they cannot be they are not subject to any imperative registration as trademarks are, for example, or patents. They acquire protection at the time when they create it. So the principal thing here is to understand in what relations these products have been created and who created them. I divided these manners into two: civil law relations and employment relations. Basically, the business relations will be a situation when one company orders software development from the other company. Employment relations will mean that the employer gave a special task to the employee to create a computer program or, for example, a database. And the other situation can be that the employment contract specifically provides for the creation of certain software products. So when there is a business relation, then there can be two situations which we can encounter. First of all, contract of commission. If one company specifically orders or commissions for the development of a particular software product and describes this product in the agreement, then the software will be owned by the customer unless there is an agreement to the contrary. Meaning, if, for example, the other company is smart and they know the law, they can provide a provision in the contract that they will capture the rights in the software, and in this case they will own them. But by operation of law, the software will be owned by software rights, exclusive rights will stay with the customer, and the developer will have the free of charge right to use the software for its own needs on the so-called non-exclusive license. So this will be a legal, so-called legal license, and there is no need in creation any other license for between these parties. The other situation may be when the company has never ordered or commissioned the software product, and this software product was created as a result of certain R&D works, of service works, or other business relations. So in this case, when the software basically is not the subject of the contract, but is the subject of, I would say, the subject of works or services created under the contract, then the software will be owned by the developer, and the customer will have the license to use it. Again, in this situation, there are some certain smart companies, the developers that are involved in R&D business or do services. They can specify in the agreement that they will capture all these exclusive rights. That's why in this situation, the lawyers have to do careful due diligence of the contracts, especially when the software companies are sold. They think they own the software, but this is not the case, because because by operation of law, or for instance by operation of contract, the software rights have always stayed with another party. So that's why our recommendation will be the careful study of the contracts and careful study, of course, of the provisions of the law, and due diligence before the sales of any software products. When we talk about the labor relations, there are cases when as I said, employer will give a task for the employee to produce a work, or will make a contract, employment contract, or again another contract specifying that the software product must be created. In this case, unless there is an agreement to the contrary, the software will be owned by the employer, meaning that the law says the rights will stay with the employer. And moral rights, as you know, of course, will stay with the employee. But again, the employers must be careful, because there can be a return back in principle in case within 3 years the employer will never commence the use of the work, will never keep it secret, or assign it to a third party. In this case, the software rights will be reverted to employee, and he will be the employer. I'm sorry, he will be the owner of the software. So in labor situations, we need to first of all do due diligence in respect of employment contracts, employment tasks, or labor tasks, and also study whether there has been any of these actions within 3 years after the software has been provided in the hands of the employer. So we must identify whether there have been any use, or whether there has been any assignment, or whether the information related to the software has been made confidential by the employer. So let's talk about the distribution and licensing. That's why basically the software programs are created. There are different strategies or models how software products are sold. There can be a direct distribution, meaning that there is an owner, and there is a licensee who is buying the product and using it on its computer. Sometimes there is a indirect distribution, meaning that the owner sells the product to the distributor, and then the distributor will license it to the end user. Also, cloud computing is becoming extremely popular nowadays all around the world. In Russia, is not an exception. So I would say software as a service model will be also popular when software will not be licensed, and there will be no copy created as a result of this model, but the software will be serviced to the end user to comply with its needs. And open source, when the software will be basically provided free to people who is interested to use it and to sometimes modify the code to apply it to the business. So many I don't know, Creative Commons, probably you've heard about it, the Linux and other models, they work under open source model. Speaking about the legal models, how software is distributed, I would say that basically the licensing and sub-licensing schemes are always involved. But sometimes there are mixed contracts when there is a supply contract and there is an end-user agreement for the user to start using the program. For instance, there is a supply for the copy of the software, and there is also a license for the user so that the user can open the key to the program and start using it on one computer or on computing network, for example. Sometimes services are also involved, and as I mentioned, these are very popular in cloud computing. Well, when the relations are basically structured on the basis of services, not on the basis of licensing. What is a license? The license is basically a permission for the use of the software, and the key thing in the license is the scope of license, meaning that what rights the licensee has and what terms of the contract are provided. For instance, it's very popular to prohibit licensee from using and modifying its product, so that the licensee uses the software as it is without any changes. Some contracts provides that this right is granted. That's why right of modification will be within the scope of right, and the user will have the right to modify the product, enter necessary changes, and create new software products on the basis of this right. Software has to be in writing. I mean, a software license has to be in writing, and it doesn't need to be registered in any state agency. Comparing, for example, a trademark or patent license, it has to be just written. General types of software licenses, I would say this would be standard, free, and open licensing. Again, in terms of the Russian law, in terms of international principles, there may be different concepts. Also, there can be copyleft licenses. They can be so-called open source licenses, and the basic principles and the key differences between them is that the free software licenses will provide a broad range of rights. They will the users will have the right to use the software for any purpose, to install the software in different computers, to have an access to a source code, and to have, as I said, the right to modify the software product. So different rights can be granted. More specifically, this is the key elements of the regular standard software license. That's where the lawyers have to pay attention. As I mentioned before, the updates and modifications are very important because not every standard license will have a right, will give a right for the modification, and will provide the automatic right to use the updates. So this has to be contractually fixed. Again, computers and copies. How many computers will be involved and how many copies will be created? Very important, who will be doing the installation and who will be caring about the maintenance of the software use. This is very important because as a result there might be a different or attached agreements to the software license that will have different nature, and they will have to be reviewed from the position of the general civil Russian law. Again, there are certain limits for the term and territory. For example, if the standard exclusive license is silent on the term, the Russian law says that it will be effective for 5 years. If we talk about the territory, if we don't mention anything about the territory in the license, for example, the server in which the software will be operated, or the address of the company, and then the license will be effective for the whole territory of Russia. Free licenses is a new concept that has been entered into force with these amendments of the Russian Civil Code. Basically, it's a free of charge license that is available to that becomes available to public, and the information has to be placed on the website of the state agency. Right now, this state agency is not defined, and we will have this state agency. We will know the state agency very soon, I believe, whether Rospatent or the Roskomnadzor, the agency which is responsible for the information protection, will be responsible for obtaining these applications. This license will be free of charge and will be effective for 5 years by default, and will be effective for the whole territory of Russia by default, meaning that you can, of course, provide different terms, and the other side has to comply with it. The free license can be granted in the event of validity of any other licenses. For instance, there may be a case when there is exclusivity relations between an exclusive license already exists between the parties. In this case, the law prohibits the licensor from giving this free license, because, as you already know, the exclusive license is exclusive because only one license can be granted. Open license is a different concept. Again, the terms have to be open to public, and this is basically the contract of adhesion. When there is a description of actions, and the user basically comply with its actions, and then the contract is regarded as concluded. So that's why this contract, the so-called open license, has to clearly define how it will be regarded, what the licensee must do in order to conclude this contract. This contract will be non-exclusive because many licensees can use this structure. Will be free of charge unless the owner wants to make it for royalty bearing, for example. But this is usually a question, because often a license has been created and implemented in Russia on the basis of the basically open source concept taken from the international practice, and such licenses are usually open source and free, and they cannot be royalty bearing. That's why I believe this license will be always free of charge in terms of the Russian law. Again, a licensor may terminate the contract in case the licensee is breaching the terms of license, and especially the so-called copyleft principles, when they have the right of the right to modify the product and create new products and doesn't comply with it, then the licensor may terminate the contract. Also, there is a so-called electronic license when the software license is described on the package or is attached to the software copy. Basically, it's again the contract of adhesion, and there is no need to sign any papers when you conclude certain actions. Then the software is regarded and licensed, and everyone can use it. Commencement of use of the software is usually defined by the terms of the license, and they will lead to consent. The electronic software license shall be free of charge unless the contract provides otherwise. Regularly they are free of charge, and I haven't heard a case when these electronic copies in Russia, based on Russian law, will be royalty bearing. So let's talk a little bit about clouds. Cloud is a model under which a company or an individual uses the services of a third party in order to host certain data or information on dedicated or shared servers, and the software applications created, they are made available to users as services over the internet. So this model involves the hosting of computer data outside of customers' premises, and that is one of the main benefits of cloud computing. The data is usually stored in locations that is often determined by the availability of the service at the moment when there is cloud computing relations. What are the benefits of cloud computing? Of course, it's significant reduction of any capital expenditures and costs in relation to obtaining the software and the license, and creating a service for the software use. Of course, there is more I would say advanced data storage capacity, because you shouldn't store everything on one and the same computer or within the same server, and I would say energy savings, because you use basically software through sharing and virtualizing the services. In the world, there are basically three more categories of cloud computing: the software as a service, platform as a service, and infrastructure as a service. These are different models depending on the functions of the applications, the functions of the usage, how the user uses this, and I would say most popular strategy would be software as a service, especially in Russia. Nowadays, many companies use it instead of obtaining any license. In terms of contractual elements, I would say that again, not always regular licensing models and services are involved in cloud computing, but leases, data storage, data transmission agreements are always involved, and that's why it's a mixed agreement or mixed relationships, and that is why the lawyers have to pay more attention to every element of cloud computing, whether it is involved or not. Data protection is very important here, and I would like to stop here, because starting from September 1st, in 7 months already, if the company would collect the personal data of citizens of Russia, then their service has to be placed in Russia. this will be the law, and that is why many international companies have now to open service and data centers, especially in Russia, in order to comply with this law. And what is more important is that the international companies will not be able to amend this principle via contract. So if the personal data of Russian citizens is collected and stored, they have to be placed on the service and data centers in Russia. These are just the figures which show that the cloud computing market in Russia is growing too, and we expect it to happen in the next few years, especially because of the political situation, and we happen that this trend will continue, and cloud market will be developing. Also, outsourcing is very popular in terms of software industry. Basically, it's not just the subcontracting or transfer of third-party rights, but it's the purchase of goods or services that one could do internally, and one could handle internally. It basically it's similar to the concept of service, but usually the whole business is outsourced. For instance, there are types of outsourcing where you can see that usually recruitment, instead of creating a recruitment department, the recruitment departments are outsourced. The software development is outsourced, and that's why the Russian law may be of assistance. And certainly, certain business and financial services may be outsourced. Speaking about legal structures, they are very similar to cloud computing because many different mixtures of agreement will be involved. Not only the services or licensing agreements, but it may be trust management agreements and other contracts that will be involved. So let's move forward to part 6, which is the last part, I believe, and we'll talk more about protection and enforcement of software. Protection of software, how we can protect. First of all, protection comes from the documents. And how we can obtain the document, one can obtain the document by registration, and that's why Russia, I would say, have a unique system of registration. You can see that registrars can be Rospatent, can be Gorodissky, because if the software is owned by, for example, an author, and he didn't transfer the rights to a company, he can deposit the software and the disk, for example, with Gorodissky. And other agencies and organizations in Russia or in other countries that help to register the software. The documents in turn, you can see here that I'm describing the Rospatent registration system. There is a bundle of documents that one should provide, and deposited materials will be a must. Because, as I said from the very beginning, the source code is the key element of the software. That's why the company or the person who wants to register the software with Rospatent has to disclose the source code. Term is very fast comparing to patent registration or trademark registration. It's 2 months, and what is important is that there is no refusal from the side of Rospatent. Rospatent can always proceed with the office actions, but can never refuse to register the software. And that's why this is I would say, a unique system of registration that one should use in terms of protection of software. This is basically the result. You will get the software registrant will get the certificate, and the information on the software will be published on the website of Rospatent. What are other methods of software registration? Basically, it's publication. Of course, if you, for example, a video game in which the software product is implemented, the better you publish it or make it online, it will serve better protection for you. Sometimes neutralization of the source code and preparatory materials will be helpful, and software registration in various systems can be also applied. For instance, our firm can provide services in terms of registration of software in the US Copyright Office, as it's very similar to the system of ROS patent registration. The only difference will be the money and the time. I think that the US copyright registration system will be lengthy comparing to ROS patent registration. And of course, we were talking today about the employment and civil law relations. That's why it's very important to document every contract where you create, on the basis of which you create the software and execute these so-called transfer acts in papers, so that all these papers can serve you well in the court action. In terms of enforcement, basically the Russian law provides for various avenues, again depending on the liability of the infringer and depending on the remedies the owner would like to seek. So administrative, civil and criminal prosecution is generally available. Different types of law enforcement agencies that are usually involved. Courts, including the Russian IP court, which has been established in 2013 and already working for 1 year and a half, has some practice in terms of infringements. Customs authorities and police departments they assist companies to fight in their market or during the exports or imports of software, and of course prosecutor's office may sometimes assist. Different services such as federal security services may be involved in terms of imports and exports of encrypted software, and I would say that this will be helpful when you need to obtain the license or approval from this agency, and of course our firm can also provide this service if you need it. Then next slides will show different differences between these avenues. There will be different avenues available, and cease and desist letter may be a good option to start because it is a cost and time efficient measure to enforce your software rights, and usually the infringer receiving the letter, understanding the liability, which is quite strict under the law, will stop the usage of the software. If the if the cease and desist letter is not working, then different prosecution and different judicial ways can be applied. So again, administrative prosecution is very useful against the imports and exports of software production facilities and regular market counterfeiting cases. For instance, when software disks are sold on the trade markets or in store, we can organize a police raid and seize all the software, so that when the administrative prosecution is accomplished, these products can be destructed. Civil prosecution is another avenue, which is, I would say, more reliable than administrative, because everything depends on the owner. Owner shall collect all the evidence. Owner must control the situation. Owner will be the plaintiff. So even though the civil action is lengthy comparing to administrative prosecution, as you can see, it provides different legal remedies for the owner, including the monetary damages or monetary compensation. It provides for preliminary and permanent injunctions and different other remedies, including publication of the court order, will be available. So again, civil prosecution will be will cost more money than administrative prosecution and take more time, but it is usually regarded as more efficient than administrative prosecution. Criminal prosecution is quite rare action, but again, because it's sometimes difficult to prove the guilt of the infringer, but for you to know that it is also possible, and it can lead to different sanctions, including the imprisonment. And I would say it's useful when we can prove that a group of people, a group of companies are involved in production of fakes or counterfeits. Again, if you have any questions, you can ask me in this chat. Otherwise, you can send me an email. When downloading this presentation, you will have my email, and I will, of course, respond. Again, please know that this topic is quite broad, and usually it may be very difficult for me to speak all about all of this within this 45 minutes. But I hope I could cover the basics, and this will help you in your practice or in your business, and our firm will be happy to assist you. Thank you very much.